Namaskar everyone and welcome back to my channel Legalese by Aditi Sahai. So moving on with today's legal maxim, it is res ipsa loquitur. It is a legal term which means the thing speaks for itself. It is a very popular doctrine in the law of torts. It is circumstantial or indirect evidence which infers negligence on the very nature of the accident that has taken place, and there is an absence of direct evidence against the defendant. Res ipsa loquitur is applied when it can be based that without the defendant being negligent, the accident would have not happened. Therefore, accidents happen all the time, and many a time it is because of someone's negligence. And in the law of torts, to prove somebody's negligence, the burden of proof is on the plaintiff, that is, someone who is the victim of the tort. It becomes very difficult to prove the defendant was at fault and also to gather evidence against his act or omission. Therefore, keeping this in mind, the principle of res ipsa loquitur came into force under the plaintiff can use circumstantial evidence to establish negligence. There are few elements of the res ipsa locator. The first is the event that caused inquiry to the plaintiff does not occur unless someone has acted negligently. Second, the evidence adduced rules out of all the possibilities of the fault of the plaintiff or third party. Third and the last, there is a duty of care of defendants towards the plaintiff which he breached. Now let us understand the development of the this principle. The roots of this principle are in common law countries, which are England in the case of Byron versus Bodley. The facts of the case were that in 1863 in England, a barrel of flour fell from the two-story building and hit the plaintiff's head. But the plaintiff could not acquire direct evidence against the defendant to allege the negligence on his part, but the court held that the judgment for the plaintiff and opined that the circumstances were different in this case and there could be a presumption of negligence. And there are few essentials of the res ipsa loquitur. It is inference of negligence. Second, exclusive control of the by the defendant. Third, freedom from contributory negligence. So thank you everyone for giving me so much love in my last video by liking, sharing and commenting. Please do subscribe Legalese for many more legal updates. Thank you.